Welcome to our second instalment of the Expert Equitable Briefing Seminar for 2020. I do hope you're all staying safe and well in isolation. These are certainly interesting times we're living in. The way we live, the way we work has all changed. So to assist you with the work part, we are presenting you today with an overview of the changes to the court process in light of COVID-19, including tips and tricks on how to best navigate the virtual court process to be an effective expert witness. This is our first virtual seminar for the series, and we do hope you enjoy the different format. Don't worry, we can't see any of you who are sitting there in your pajamas. We can't see anyone. There is a question function available, which should be down in the bottom right-hand corner. So I would encourage you to send any questions that you have as they arise. We'll be moderating these questions and sending them to the presenters to either answer during the course of their presentation or at the end. Now, before I move on to introduce our speakers, I'd like to acknowledge the traditional owners and custodians of the land on which I'm currently on, the Gadigal people of the Eora Nation. Today, I'm pleased to introduce three fabulous speakers, all of whom are highly regarded in environment and planning law sphere. For those of you who attended our seminar last year, you will recognise two of our speakers. First of all, I would like to introduce Justice Duggan. Justice Duggan was appointed to the Land and Environment Court on the 10th of September 2019. Prior to this, she was the head of chambers at Martin Place Chambers, the leading specialist in environmental planning and property law. Justice Duggan was admitted as a solicitor in New South Wales in 1988 and called to the bar in 1995 and appointed senior counsel in 2010. As a barrister, Justice Duggan's experience includes development appeals, criminal prosecutions, land valuation and acquisition hearings, and coronial inquiries. And a little like myself, Justice Duggan has a taste for travel, fabulous shoes, and even better champagne. Our next presenter, who is new to this series, is Senior Counsel Ian Hemmings. Ian is now the head of Martin Place Chambers. He was called to the bar in 1996 and appointed Senior Counsel in 2013. Ian's practice focuses primarily on valuation, local government, and planning and environmental law. He regularly appears in the Land and Environment Court, the Court of Appeal, and the High Court. And when he's not appearing as an advocate, you'll find him training for his next Ironman event. Our final presenter is Ms. Janet McKelvey, who's counsel at Martin Place Chambers. Janet was admitted to practice as a lawyer in 2006 and called to the bar in 2013. Janet specialises in planning and environmental law and regularly appears in the Land and Environment Court and the Court of Appeal. When Janet's not appearing in court, she's an avid Lego enthusiast, plays the guitar, and you may also see the piano in the background, and loves to travel to unusual places. So now I'm going to pass over to Justice Duggan, who's going to kick things off.
That would be me. Hello, everybody. I'm sitting in my chambers today, so this isn't my home. There's no pets or anything, but you can check out what's on my bookshelves. And the reason why I am sitting here and talking to you from my chambers is we come into court every day. And even though there's this COVID lockdown and you're all working from home, if you go to the lists every day and have a look, you'll see all of the judges of the Supreme Court of New South Wales and the Land and Environment Court have a court number next to them. And that's because we do sit in court even when we're doing these remote hearings. And that makes how we conduct the hearings a little bit unusual from somewhere like the Federal Court where they seem to be doing their hearings from home. The reason why I raise this is you should be aware that every single court in any jurisdiction is doing this differently. What I mean by that is they'll be using different software, they'll have different technology available to them, and they'll have different hardware available to them. For example, in the Land and Environment Court, the first week that this all went to hell, we had Telstra who were monitoring and providing us with a telephone service to have telephone hearings. Halfway through day one, Telstra sacked us because they had too much traffic and they couldn't manage us anymore. So then we went to these 1981-looking phones in the court where you could only call out 2 people, and it sounded like everybody was in a fish tank. With every week, things change, and what we now have is we've got better bandwidth, we've got better telephones, we've got telephone lines that only now occasionally drop out rather than every 5 minutes, and we have some AV capacity but not a lot. In the Supreme Court, they have some AV capacity, particularly for the Court of Appeal, not so much for the single judges. And in the local court and the district court, they're pretty much keeping their AV for people in custody. So the reason why you need to know that every court is different is that you will need to check each court website before you appear and just see what system they have in place and how to access it. In the Land and Environment Court, we have, and most of the other courts do, and I'm going to do this so you can see how useless it is. We have what's called a protocol, and most of the other courts have that. And it's really important that you look at that because it gives you really good information, such as how to dial in, how to log into the AV, and those types of things. We are all learning as we go along, and most courts will allow you, and Ian will speak to this in relation to some matters that he's been doing. Most courts will allow you to have a bit of a trial run the afternoon before or early in the morning so that everybody can make sure that their system is working and that they've got the right software to enable them to use the hardware that the court has. So you need to check, and the protocol's the best place to find that at the moment. As far as the sorts of hearings that I've been doing, I've done limited AVL because we've only got one AVL system in the court that I practice in. But I've been doing a lot of hearings by telephone. And the experience of not having people in my courtroom is really quite weird. The first week I thought, oh, thank God I don't have those barristers annoying me and I can sit here and do what I like and roll my eyes and pretend I'm listening when I'm really not and all of that sort of stuff. But now I'm really lonely and I miss you guys. And I'm sort of sitting here thinking, gee, I wish Ian Hemmings would come along and annoy me again or something like that. So it's hard, but it's challenging, but it's interesting. But of particular moment when we're doing these sorts of hearings is even if you are doing AVL or telephone, which is more our case, you don't get the same experience that you do when you're in the courtroom with people. Firstly, it's very hard, particularly on the telephone, to pick up on social cues. So, for example, if somebody says something to me in a joking way, if they're in front of me, they'll pull a face and I'll know it's a joke. But if they're on the telephone or they're only audio linked in on the AVL, you don't get that visual cue. Or I was hearing submissions from somebody the other day and they just went quiet and I said, have you dropped out? And he said, no, Your Honour, I'm just turning the pages trying to find the document that I want to take you to. So there was just deathly silence for 5 minutes while he looked up this document. And none of us would have known what was going on if he hadn't given us that narrative. So that's quite difficult with not having the social cues. The other thing which is really difficult is the degree of concentration that is required when all you're doing is either listening to somebody on the telephone or you just have one person speaking, because most of these AVL systems is when you have one person speaking, they come up as the primary visual on your screen. The degree of concentration that's required is intense because you're trying to hear what the person is saying, you're trying to look at the document at the same time, and you're trying to put out of your head the other noises that you're hearing over the line, such as other people turning pages or people's dogs barking and things like that. So it's quite exhausting by the end of the day, so much more than an ordinary hearing, and that really did surprise me. The other thing you need to know is one of the big limitations with the court using these systems is that we have to record all of our hearings. So the court monitoring system has to be able to prepare a transcript from these proceedings. And what they usually do when they sit in court is they see who's speaking and they make a little note in their computer so that they can go back to court reporting services, type up the transcript and change the speaker. They don't have that advantage anymore. Effectively what they have is a microphone pointing down at my telephone. And they don't know, particularly if it's it seems to be more two men speaking, it's very hard for them to distinguish between the speakers. So the capacity for them to get a good transcript is difficult. And I now say to them when I go into my courtroom that they are the ones that are in charge and they need to tell me if they can't hear somebody, if they're not getting a good transcript or if they don't know who's speaking. And the two main things that they've said to me on a number of occasions is that particularly when you're on the telephone, you need to say your name before you speak each and every time, because that way they can make that note in their system. The other thing that they ask is that the people who aren't speaking mute their phones, again, for the reason that people turning papers, which in a courtroom would not have a loud noise, is amplified when you're doing it next to the microphone, which is recording your voice. So they're the two things that they really appreciate. But that's also why I sit in the courtroom, because I need to have the monitor there to monitor and record what you're saying. The other thing that you need to understand is that everybody has quite different technological capacities. When you come to Ian later, Ian is well known for the fact that every time he goes to court, he travels with 4 or 5 screens, one of which is so large that he could have us all in life-size version fully formed on his screens. Some of the large law firms have these digital conference rooms where there are 12 cameras and 15 screens. But you've also got somebody who's working on a first version iPad, where if you have more than 2 people on the screen, they're so small that they can't be seen. So you have to make sure that when you're looking at a digital platform and a digital format, that you're going to manage not only the people who are at the high end of the tech system, but people who are at the lower end of the tech system as well. So what that means is that when you're in court and when we're dealing with it in AVL or telephone, is that we need to try and streamline the system of giving evidence. And for those of you who have given evidence in the past, you'll know that a lot of time is spent with people trying to find documents or to be at the page that the barrister wants to ask you about when you're being cross-examined. We're trying to avoid that type of breakdown, because when you're sitting in a room with the same person, it's easy to see that they're looking at the wrong folder, and it's easy to direct them to the document that you want them to see, or as a last resort, hand them up another copy. So what the courts are trying to do, and particularly at what our court is trying to do, is to get everybody working off a single bundle which is consistent across every person who is going to be participating in the court process. So what we have are experts used to take their own reports up to the witness box, and they'd take their own copy of documents that they wanted to refer to. And they wouldn't be using the court book, which is what the court and the barristers would be using. Now what we're requiring is that the experts embrace the court book rather than their own copy of documents, because that way we can say go to page 46 and everybody's in the same bundle, going to the same page 46, and it's just a lot easier. And it's a lot easier for the expert to be able to follow along what's going on if they have the same documents. So what we are finding is that it's really important that the experts ask for and obtain well before the hearing that copy of the court book, so that they can tag it up and they can mark it up and they can own it, so that when they're giving their evidence, they know where documents are and they know how to find them. The other thing that we're really noticing is people can't point to things. And a lot of experts, when they're giving their evidence, like to point to a document, or they like to draw on a document and try and explain what can often be quite difficult concepts visually. And I'm a very visual person, and I find that a drawing helps me understand a lot more than somebody just trying to explain something to me in words. We can't do that in this digital system. As I held up the COVID protocol for you, it's flipped, it's mirror reversed, it's so small you can't read it, and you don't know what you're pointing to. So what people are having to do is to think of new and different ways to present their evidence. One way is making sure you have good quality PDFs and blowing up sections that you particularly want the court to look at, annotating things, drawing on things before you get into the witness box so that the judge has them and the other side has them when you're giving your evidence by way of explanation. And those types of thinking outside the box in relation to how you are going to present is a fundamental matter for experts, because at the end of the day, your evidence is only as good as your capacity to convey the message. And if you can't convey the message best in words, you need to think of a way that you can do it in this digital system, which means thinking about it before the night before the hearing, because some of these documents and some of these measures that we adopt need to be implemented before the day of the hearing, either to make sure people have software or to make sure people have the documents. A lot of people seem to think that this system will work because they'll just have a Dropbox and they'll just throw all of the documents into the Dropbox, and everybody will sit on the bench or at the bar table and call up digital documents during the course of the hearing. That works when you're multi-screened. It doesn't work if you've only got one screen, because the screen you're looking at is the screen that's recording you. So a digital exchange of documents during the course of the hearing really won't work in a lot of occasions. The other thing is I have to physically staple an exhibit slip onto an exhibit, and I need a hard copy. So sending all of the documents digitally doesn't allow the court to perform the functions that it's required to do, including keeping secure the exhibits that are going to be the evidence that we look at for the purposes of determining the hearing. So there's a couple of things that you need to think about. How am I going to present my evidence in a really effective and compelling way when I can't point to something, draw on something, or deliver something while I'm giving my evidence? So that means you've got to go through the court book, get to know it, check your own report to make sure it's legible, check to make sure that any document you want to go to is available at a quality or a size that enables you to make the points you want to make easily. I'll give you an example. A survey plan. When it is photocopied onto an A4 piece of paper, you'll never be able to read the spot levels. So if there's a particular part of the site or a particular level that you need to go to, you need to make sure that the document is big enough that that spot level can be identified and legible. You also need to make sure that the judge is going to be able to find the spot level you want to go to rather than the 500 other spot levels. So think about highlighting it. If you've got a page full of data, an Excel spreadsheet, for example, which for reasons I've never been able to understand is always written at 6-point font, when that is reduced to an A4 size A4 size page, nobody can read it. So identifying the lines in the Excel spreadsheet you want to go to by highlighting it, putting it on an A3 document and sending it up to the judge beforehand, not you, your solicitor, helps. PDF architectural plans. The photocopy department in large law firms is personed by people whose sole job is to photocopy and collate documents. They don't know not to hit scale to fit page when they are photocopying a PDF. They photocopy a PDF so that it looks the best it does. But when you scale to fit page, you throw out the scale in the original PDF architectural plans. So the plan stretches or shrinks depending on which side it's on. So you need to be able to give instructions to people so that they can then give instructions to their photocopy people, so that when you get to court, the judge doesn't say to you, but hang on, that dimension says 4 metres and when I scale it, it's only 2. To think about early and give instructions in relation to. And things like photographs in a report, they can be very small. You might want greater detail. You may want it as something better than just a scanned PDF. Give those instructions to the solicitor so that a document adequate for your purposes can be prepared. Ian's going to talk to you about what's called cross-examination bundles, which is something which is coming into play where particular documents are gathered together so that people don't have to scan large volumes of documents. But I'm also encouraging people to think about putting a bundle together for their evidence in chief so that those documents are available to everybody, accessible and easily able to be accessed when you want to refer to them, rather than flipping through multiple volumes of a court book to get to 2 or 3 documents. The other thing that I wanted to talk to you about is that with this new system, we're all learning and we all learn more each time we do a case. And sometimes you'll hear from one of your colleagues that something worked really well or something did not work well at all. Or even your own experience of giving evidence that something didn't work. You didn't have your documents or you couldn't hear what was going on or something like that. You need to get back into the feedback loop and tell people so that these the kinks in the system can be ironed out as best they can. As I said, the court's happy in most cases to do trial run-throughs. The court's happy to listen to options that are being put forward to make the system work better. And barristers who are at the front line of getting these cases ready and preparing them in the best way that's going to assist the judge are very happy to take on board these new suggestions no matter where they come from. So don't sit quietly. It's your evidence, it's your presentation, and you need to make sure it's the best it can be. Don't just sit with a second-rate system because somebody's told you that that's what they've got. There's a couple of other things that you also should know or need to know. One is I can see and hear you. And I can see and hear you before the matter is called. So if you're talking about me, I'll hear it. If you're checking your teeth for the spinach omelette you had for breakfast, I'll see it. You need to make sure you've done all of those things before the matter is called, because once the matter is called, it's recording, but I can see all of that beforehand. So think about things like, do you really want to have your coffee while you're giving evidence out of the world's best lover coffee cup, or whether you're going to present a different face the way the court's running. The other thing that is important is to have patience. As I said, we've experienced a large number of dropouts. We've experienced trouble with bandwidth. And as I said, the court's trying to fix these things. And what you see is things are never the same. So on one day, your hearing may start at 10. On another day, your hearing may start at 11. On another day, it might start at 8:30. The reason why we're staggering these times is that when everybody was starting at 10, the system would fail. It would drop out much more. So we're staggering start times. So you need to check court list or ask the lawyers to tell you what's going to happen. The other thing is dropouts will happen and you need to have a plan. For me, for example, I tell the barristers to email my associate if they've dropped out, and we stop and wait for them to come back in. If it's an AVL, it's fine because I can see you're gone. But if it's a telephone, it's very difficult to know whether the right people are on the line. so we have little plan Bs. The other thing that's going to be important, and I do not know the answer to this, and fortunately it's not something that I have to worry about, but I'm sure Ian and Janet will speak to you about it, is there is no replacement for the digital post-it note that you used to hand to the barrister from the back of the court that says, no, he's lying, it's a 46 dB difference. So there needs to be some capacity, and again, you need to talk this through and work it out, for you to be able to have input during the hearing, not just when you're giving evidence. And importantly, for barristers and solicitors to get instructions from clients. So there's a whole lot of that sort of pre-hearing work that now needs to be done so that people know what the plan is, how to execute the plan, and how to make sure their evidence works really works to an optimum when they're giving the evidence. So I said I've got three things that I put on my bench now, which is the 3 Ps, which is preparation, patience, and perseverance. And that's all we can ask you to do. And hopefully, as I said, the kinks will work out. Now, Linda has asked whether the kinks in the system are likely to lead to appeals. The answer to that question is probably yes. There have been a few appeals already where people have been forced into hearings that are not suitable to this type of system. The change in the legislation that allows us to have these types of hearings rather than face-to-face hearings requires the court to be satisfied that it is fair in all of the circumstances of the case that the matter proceed by way of AVL or telephone. Fairness is very subjective, and what one judge thinks is fair, another judge or another 3 judges may not. So yes, there will be and there may be appeals, but more likely what will happen is that a hearing will start, the expectations of the parties that it could be done by that route proves incorrect, and the matter will have to be adjourned. But what we're doing and what most courts are doing are what we call triaging the list, which means we call through every matter we have and ask people, is this something that can be dealt with through this different system? If both parties say no, then realistically you can't proceed. If one party says yes and the other party says no, then there needs to be an argument. But the balance is always going to be to a fair trial. So you have to ensure that a fair trial happens. And in some cases, that just can't happen in the current system, and you'll just be pushed further off in the list. So you'll have a hearing date later in the year. You won't have one now. Now, I think that's the only question that I had that I was asked, and I think that's the only thing that I wanted to say. So I will pass you now over to Ian and Janet so they can tell you what it's like on the other side of the bar table and how difficult it is for them and how they're going to make me understand something when they can't shake me and point to me and go, my God, what are you doing, Judge? So thank you very much for listening to me.
Well, the best thing about that presentation is I'm very encouraged to know that the judge wants us back in a courtroom. So that's good news for everyone. Janet and I have talked about the best way to present, for us to present on this, and we're going to take a somewhat cooperative approach. So we want to try and discuss with you the pros and cons of trying to deal with the giving of evidence and the taking of evidence via video link. But before we go to the specifics of that, I was going to ask Janet to give you a little refresher on your cross-examination tactics and techniques so we can then talk about the video specifics with that background.
Thanks, Ian. So one of the issues you might recall from if you came to the last presentation that I did with Clayton Utes was to run through, in particular, the issues often faced by women when giving evidence, but also the general cut and thrust of what happens when a barrister tries to cross-examine you as an expert witness. So the main things that need to be remembered are that you're there for your competence. not necessarily for your confidence. So, but it is always easier if a witness is reasonably confident in giving their evidence, and that all comes from preparation. We've had previous discussions in this forum about what you need to do to prepare. It's not a memory test, giving evidence, but it certainly is an advantage if you are well and truly across all of the evidence that you've put on, as well as your counterpart's evidence, because often, particularly in the Land and Environment Court scenario, you give concurrent evidence. So you're literally sitting next to your counterpart when giving evidence, and there is a bit more of a discussion almost that happens as part of the cross-examination process. So it is important that you do have you're certain about what your view is, but also that you're open to that view being challenged either by your counterpart or by the barrister asking you questions, and that you can rationally, calmly and confidently explain to the judge, who is ultimately there to make the decision, what your evidence is and why, because it's the why that's really important. So the usual little prep discussion that barristers will have with experts in terms of giving evidence and particularly surviving cross-examination is only to answer the question you've been asked, for example. There's an example that now Acting Commissioner Clay used to always give when speaking to an expert in preparation before a hearing, is the question you might get asked is, did you have breakfast this morning? The answer is either yes or no. It's not, yes, I had toast, or I usually have breakfast but I didn't this morning. You've got to carefully listen to the question and answer only the question you're asked. That's a real skill to develop, and it won't always be successfully achieved, but certainly that's what you're aiming for when giving evidence, particularly in response to cross-examination questions. Because the questioner should be drawing out of you what they want, and so it should be quite a limited scope of inquiry. And so it's important to keep that in mind when being cross-examined. Also, you're allowed to say if you don't understand the question. So if either you've misheard or you're not quite sure what's going on, or if there's two parts to a question and you're not quite sure what you're supposed to be answering, you're allowed to say quite bluntly, I don't understand the question, or could you please break that down for me? You don't need to be embarrassed or bashful about that. You're entitled to ask and to understand what's being asked of you. The other, another matter is about just courtroom tactics, if you like. When questions get asked, there's an opportunity for a barrister, your barrister, or the person representing your side of the case, to object to the question. So it's often good court craft to wait a beat if a question is asked before you answer it, so you know if there's going to be an objection or not. Because as soon as a barrister on your side of the table starts speaking, you should stop until the objection is dealt with before the question is then probably re-asked and you have to answer it. There's a couple of other little things. Court attire, and we can discuss this more in terms of some modern examples that have become a bit of a problem in the AVL sense. But even in court, in a personal court, when you're giving evidence in person in court, professional dress, keep your shoes on. You wouldn't think that that was an issue, but there have been some examples where an expert has gotten a little bit comfortable, slipped the shoes off, and then been asked to point something out, so everybody then knows they don't have the shoes on. It's surprising that that would happen, but it does, and so it's always a useful tip to keep in mind. Also, there's a number of subtle things that you can do, which will need to be made unsubtle in the current climate. When you're giving evidence, particularly concurrent evidence, is to indicate to the barrister your own side, whether you want to comment on a particular issue that's been raised with your counterpart. Either you can say it bluntly at the end of your counterpart's answer that you can just ask, can I please comment on that, or I have a comment about that. What that says to your side is to make sure that in reply examination, or even to the judge, that there's more to be heard about that. So that's a useful indicator to those who are asking questions and those in the courtroom to understand your evidence completely, and that there might be an issue with what's being said against you. Unfortunately, some of that comes from body language, and that sort of segues us into some of the issues that we're experiencing with AVL hearings in particular, and certainly with telephone hearings, in that we can't see you. So I think it's important that we get an understanding of how things do sort of change in the AVL scenario. So Ian, did you want to head through we've got a list, everybody. We have a list.
Thank you. So there are two things specifically that I want to add to what Janet's just said, which is specific to the video environment. The first is the not answering the question that you don't hear, or answering the question that you thought you heard. If you don't hear, as Janet said, ask the question to be put again, because if you're in the courtroom, usually you don't hear it because everyone has the same background noise that's come over the top of the question. It might just be that it's your link that drops out and everyone else knows exactly what's going on in the virtual courtroom and you're the only one that missed out. Don't be afraid to make sure that you know what the question is you're being asked before you try and ask it. And the other, probably the most difficult thing that I've found in the various forms of online hearings and or conferences I've been doing, is stopping people talking over the top of each other. In the courtroom, we try not to do it anyway, although sledging is a great tactic and is almost impossible when you're trying to use a video link. But witnesses talking over the top of each other and barristers or advocates talking over the top of witnesses other than objecting is something that has to be avoided, because you just can't hear each other. Most of the systems simply won't accommodate two people talking at the same time. So Janet and I then, as she said, we've got a series of topics to talk about, and the first, and probably that which causes people the most concern, is just the technology. The judge has commented upon the technology aspects and the variety of them already, and can I impress upon you the importance of having the practice run beforehand? As she said, all the courts are operating using different technology, and so even if you've got technology number one mastered, you don't know what you're going to be doing the next day, and you need to be in control of the court's technology, your own technology, and you need a backup. Because I was, by way of example, I was lucky enough, I think is the way I describe it, to have one of the first civil trials that they were experimenting in the Court of Appeal. And that was very early days and they're not much better, but all they were doing was having one camera at the back of the room looking down on the bench and speakers in the ceiling where your voice was booming out from those speakers. And at one stage the computer was working, but the computer video was working, but the audio wasn't working. So I was trying to talk to the court via the video link while holding a mobile phone against my ear and turning appeal book pages. It was not an awfully convenient way to go. You need to have various versions of technology to make your way through. But as the judge said, don't panic. She had 3 Ps. I've got 5 or sometimes 6 Ps that I'm going to talk about later. Don't panic. Everyone's being as patient as they can. Janet, do you want to say anything about technology?
Only that it's a disadvantage for everybody. So don't feel bad about the fact that the technology might fail. And also, because everybody's adapting to it, as a matter of practice, practitioners I find are being quite friendly to each other almost, which is rare for all of us. They're being friendly in the sense of, I had a matter where in reply submissions, actually Mr. Hemmings was on the other side, but in reply submissions, there was a third party that had given the reply submissions, and he got to the end. It was over telephone, and we got to the end and it was just stone cold silence because the judge's phone line had dropped out. And so he had to go back and do all of those reply submissions, and at the end he'd sort of said to everybody, did I get everything? Because we were taking notes when he was speaking, and so he wasn't sure if he'd covered off exactly the same issues. And so
I did.
It's been quite...
Don't talk over each other.
It's been a reasonably friendly process, put it that way, because everybody is struggling with it. So if you are struggling with it, there's nothing to feel bad about. And as the judges, the courts have been quite patient with everybody because they're having the same issues.
Now, can we talk about it from the point of view of the expert witness, because that's the main focus of this. Janet and I did a pros and cons for the judge, for the cross-examiner and for the witness, and we worked out that basically video cross-examination is bad for everyone except for the witness. To the extent there are advantages or disadvantages, at the end of the day, the person that gets the most significant advantage from the video cross-examination is the witness. And we'll try and show what that is through a couple of these topics, but the first of those is one that the judge has already commented upon, and that's body language. Body language is something that a judge relies upon and a cross-examiner relies upon a lot in order to determine whether you're getting under the witness's skin if you're the cross-examiner, or whether the judge thinks the witness is telling little white lies or is genuinely just enthusiastic about the evidence he or she is giving. You don't see that through the video link. That's a problem for the judge to know whether or not she thinks the witness is telling the truth. It's a problem for the cross-examiner to know whether he or she has got the witness. And so that means all those things are of benefit to the witness because you're able to be much more distant from the cross-examiner and the judge. That it led into a topic that Janet and I talked about, a heading for it, and I thought the best heading we could have for it was just to be honest about it, and that's intimidation. And intimidation has a very important role in cross-examination, and it's an important role which doesn't just come from an advocate attempting to intimidate a witness into hopefully either tripping herself up or telling the truth. It starts from the very design of the courtroom. If you think about the way a courtroom is set up, the judge is up high and up the top. The witness is exposed at an intermediate level, sitting between the bar table and the judge, so they've got no one they can turn to. Everyone can stare at them. Generally, the room is designed to make them feel as uncomfortable as possible. The idea being most people don't lie well if they're scared or nervous. Again, you lose all of that if you are now trying to do it over a video link. The only advantage, and at some stage I might get the judge to see if she thinks it's an advantage or not, the only advantage appears to be that in the courtroom setup, usually the judge is looking side on to a witness and doesn't actually get to see their facial expressions as they're trying to deal with questions or trying to answer questions, whereas now with this setup, the witness is face on to the judge. Janet? So
instead of being that metre or so apart, you are square on. But the other thing that on the body language front, that, as I said earlier, that we miss is if you desperately want to say something in response to what someone else has said, or you want to make a reaction to something someone else has said, it's much more difficult for us to pick up on those notes. When all it requires is for you to look at us. But when you're in an AV situation, we don't know where you're looking, and there's no other way to communicate to us. So it's a bit tricky in terms of working out or best capturing or recapturing that body language advantage that you get between witnesses and an advocate. The other thing that sort of flows from the intimidation topic, which is a terrible name, but we could not come up with anything better because that's really what it is in some respects. An advantage that flows from that in this system, though, is that you will have a preparation of a cross-examination book. And so there will be documents in that book that you will have a copy of in advance that you might be like, what are they giving me this for? Because you're basically getting a heads up on what you're going to be cross-examined on, and that is a significant advantage to the witness. It's probably also an advantage to the judge because they can see where the evidence is going to go, but it is a substantial tactical disadvantage to the cross-examiner because you sort of get told. The other thing that's problematic from the cross-examiner's perspective. So we have to think about all of this really in advance, much more in advance than we usually would in terms of preparing cross-examination and what documents we might need, etc. And there might be a situation, firstly, that should lead to an advantage to the judge because the cross-examination should be much tighter and much more disciplined. But it also leads to the disadvantage of if there's an answer that's given and a cross-examiner wants to explore that topic with the witness, if the documents that are required to explore that topic aren't in the book, it becomes a bit difficult. As the judge referred to earlier, it's often sometimes much easier just to say, oh, well, if you don't have a copy of X, here is a copy and hand it up. You can't do that here. So there's a few technical problems that will make the cross-examination potentially a bit more clunky. But it should be, in theory at least, shorter, which is also probably an advantage to the witness, I would have thought.
The cross-examination book, I think, has got to probably be the single greatest advantage for the witness and the single greatest disadvantage for the cross-examiner, as Janet said, not just because that means we have to get ready, but you get given everything that otherwise we would be able to show you in the witness box for the first time, hopefully to take you by surprise. And the judge referred to the 3 Ps before. My favourite's the 6 Ps, but I only use 5 of them at the moment. That proper preparation prevents poor performance. If you get the cross-examination bundle, read it, because that's going to tell you where the cross-examiner is intending to go. An advantage that appears to us to work in everyone's favour, except for, I suppose, well, no, including the court, because I was going to say because everyone's working at home. The judge has just told her that's not a bedroom. But the fact that you're working at home has to be an advantage to everyone. If you think about the normal environment in which you are giving evidence in the courtroom, especially if you've got concurrent evidence, small witness boxes with 1 or 2 and sometimes more other witnesses sharing that witness box, and you're attempting to have on that witness box access to all the materials that you need in order to maintain your position, it simply doesn't compare at all to the materials and resources you had available to you for preparation. Now you can be sitting in a witness box and you have access to every piece of information that you wanted to prepare for it and you think you need for the purposes of the cross-examination and attempting to deal with it. That obviously appears to us to be a significant advantage to everyone. I think I interrupted you before, Janet.
No, all good. The question about the environment also then flows into the idea of, well, proper court attire, which I mentioned earlier. You'd be surprised. There's a couple of constant reminders about particularly appearing by telephone, that it's not a casual telephone conversation, and appearing by video, to make sure that you are still appropriately dressed, that the background that will be seen will be appropriate. There's been a pretty funny example floating around from Florida that I think a number of news organisations have picked up, where one of the judges in the jurisdiction in Florida had to write to all practitioners to remind them that it's still court, and that he'd had a male lawyer appear shirtless in court, that it'd be no concern for ill grooming, that someone appeared from in bed, someone had appeared from next to a pool, basically saying, everybody, it's still court, so you still need to deport yourself in the same way that you would expect in a courtroom setting, and particularly in terms of the language used and so forth. So I think that's also important. So notwithstanding that it's still comfortable at home, you shouldn't be too comfortable. Having said that, I have appeared on a number of occasions wearing Ugg boots, but nobody gets to see that, so it's fine.
That then leads into another one of the topics that the judge raised, and that's the post-it note, or to express it in a different way, it's getting the support services, and this falls into two different categories. It's support services that you as a witness or as solicitors are providing to advocates during the course of cross-examination on the one hand, and then support services that are being provided to you as the witness. And we deal with the second one first. When you're in the witness box, you're the only person that's meant to be giving evidence. And Janet and I were trying to talk about, in fact, what the offence would be, but there can be no doubt that when you are in the witness box, the evidence is meant to be yours. That's easy in a courtroom. You're not allowed to have someone sitting next to you whispering in your ear what the answer is meant to be. You don't have someone in a courtroom opening up folders for you and giving you the piece of paper that will answer the question for you that's just been asked. You have all probably seen or suffered from the don't look at her question coming from the cross-examiner. Her nodding her head isn't going to help you. Just pay attention to my question. You're not getting any help from anyone else. That needs to be continued when you're giving this virtual evidence. Now, the desire to have an iPad sitting next to you where you've got your advocate sending you a message, or whether you've got your solicitor trying to feed you an answer, or you've got your support staff actually writing answers for you, although the temptation to do that might be almost not possible to overcome, don't succumb to that temptation, because that will be a disaster professionally and reputationally if that is discovered. Now, I anticipate that what's going to happen, if it doesn't happen as part of the court's as of course introduction for a witness, it will be every cross-examiner's first series of questions to make sure that you as a witness under oath tell the court that you're only going to give your own evidence, that you haven't got there anyone assisting you and not relying upon the assistance of anyone else. So because for you it's going to be easy to get access to that, simple answer is don't do it. For the advocate, and then the services that you can provide to the advocate, at the moment it's difficult because people aren't getting used to it. But Janet and I, again, were talking about this morning, and I anticipate that things are going to change when things go back to normal, because the additional advantage that I'm getting during the course of presentation of appeals, where my juniors are able to message me, and they're able to instant message me. So I'm not worrying about post-it notes coming from the back of the courtroom being written up that are unintelligible, then I've got to try and find a time to read it. They're coming up on the screen as I'm going, and I'm able to respond to it as I'm going, and I'm able to type messages to my juniors or my expert as I'm going. It's a system that, in fact, improves on the post-it note. We all need to get used to the technology, but it is something which I think we'll all need to make sure we take more significant advantage of. You've probably noticed Janet and I are doing it a little bit, even just in this process. It's a very different experience when you are in court with the benefit of a junior. But the two of you are in entirely different locations, and the only way you can see your junior is on the same video link that the court is watching. Normally the junior can tug on your robes or whisper in your ear, to actually have to look at them. And sometimes, I was in court last week, and if your honours will just wait a moment while I wait for my junior to either nod or not his head, so you can then see if you're getting a response from your junior. Well, it's new technology and we'll get used to it.
But what's also been quite useful, and this comes from an issue that the judge raised, is, for example, the way Section 34 conciliations are working in the Land and Environment Court. They're being done by telephone, but what's happening is both sides then will have either a Microsoft Teams or a Zoom or something set up so that you are actually communicating with your own team and everybody's on the telephone at the same time. And what's been quite useful about that process is because it's got the chat functions and so forth, and you can share documents that way, that's all been happening, but virtually instead of, as Ian says, instead of someone passing you a note or whispering in your ear. It makes it a much smoother process for the advocate. It makes us look really clever and as though we're not being things, even though we might be. And so in terms of not giving away something that, say if a question's asked that is catastrophic to your own case, you have to sort of, usually the advocate can hide the dismay at the answer that's being given because that's the job. But the flurry of activity around in a courtroom might give away that the answer was significant or that it was detrimental in some way. Whereas if it's all being done virtually via, lots of people are using WhatsApp to send messages if the other video conferencing's not available. So, or for example, if the court is being done by video, you have to do it by WhatsApp or some other arrangement. So it's got some real advantages in terms of making it a much smoother process and making us look better, which is always something to be encouraged. But it also it does keep that level of calm, but it can be really efficient, particularly with the sharing of documents immediately. It can be really good. So hopefully, as we all get used to it, it'll work a bit more seamlessly. The other thing that will, I think, come out of this whole process, there's got to be some good things, right? One of the things I think will come out of this process is the Land and Environment Court is already moving to doing paperless trials, particularly in the Class 3 compulsory acquisition space. I think as people are getting more used to the technology, that will just become more common because obviously experts are probably being briefed electronically, the barristers are being briefed electronically, because it's so hard to get things moved around at the moment. And instead of being able to just deliver a couple of briefs to chambers, you've suddenly got to send maybe the Silk's brief to their home and the junior's brief to their home, and suddenly everybody's far-flung instead of it just all being in the city. So I think there's some real advantages in terms of what might come out of this. And if it's the case also that conferences and so forth in terms of pre-trial preparation, particularly for regional witnesses, if there's a prospect that AV conferencing is even used in preparation rather than having to physically all meet all the time, I think there's some real advantages and cost savings to be achieved, which will be good, I think. I think that's all we wanted to cover off, I think, Ian, wasn't it?
Yes, they were the topics that we had, other than to say, where are you? The female faces that we're getting, at least in my practice area of most in the Land and Environment Court, and most specifically, I suppose, in the resumption valuation world. I know I'm looking for fresh faces. I know the judges and commissioners are sick of hearing from the same people, and maybe even hearing the same thing from the same people over and over again. It's not it is a scary experience. We make that deliberate. We've told you it's meant to be intimidating. But the court's looking for you. The advocates are looking for you. Janet and I, again, were talking about it and wondering, as part of the question and answer, if you want to, if there's something that you as experts think from the point of view of whether it's the solicitors, the barristers or the court can do to assist you getting in there. Well, I'd certainly like to know what it is, because I need some new witnesses.
Emma, I think we've Okay. I just want to say thank you to everyone, particularly our presenters today, for taking the time and explaining the changes to the court process. I think you can all agree it was most beneficial. There was one question that did come up, which may not have come through, was a question about the court book, about how far in advance is the court book to be provided?
I can answer that. One of the things that we are doing is we're having what's called a case management mention of all of the hearings about 2 weeks before the hearing. And the purpose for that is to ensure that these things are being done, the cross-examination books and the court books. So we're trying to get them done about 2 weeks before, but we're in the hands of the parties. What you need to say to your solicitor, whoever's instructing you, is, I need it no later than this date in order for me to look at it, so that there's an impetus to get it done early. We're not having a catch-up. We're not looking at people who aren't complying with directions nearly as much as we used to, because everybody wants this information in time. So it seems to be working. And also there are less cases going through the court at the moment, so people don't have the pressure of running 5 and 6 trials at the same time. So you should get it, best case scenario, about 2 weeks before the hearing for the court book, and about 1 week before the hearing for the cross-examination book. That's the goal.
Okay, thank you. There's also another question just popped in. Is it possible to get Janet and Ian's top 10 tips for preparation in writing? Are you guys happy to give away your secrets?
I'm sure we can put together a list that can be disseminated.
Fabulous. Thank you. So, well, there's no round of applause anymore. I was madly thinking about how we do it. So, from me, thank you very much for your time today. Greatly appreciated. And thank you for everyone else for tuning in. Hope you're all staying safe and well. And we would encourage you to put forward any ideas that you may have about future content for these seminars. If there's anything in particular you would like to hear about or anyone speak about, please just email us and let us know. We're happy to entertain any ideas. So on that note, thank you all for coming. And you can now get back into your PJs, and I actually admit I have my UGG boots on. So thanks again, and we'll see you at our next one, which we'll email out to you eventually. So thank you.
Thanks, Emma.
Emma.